The judgment was a startling judgment. It was a remarkable judgment. It's I think, a potentially watershed kind of judgment in terms of the politics of the judiciary and how the government responds to judgments that are adverse, which overturn its decisions. So I think it's terribly important for us to think about how the establishment and how the government responds to this judgment. One thinks back to the 90s and when President Mandela, in the famous Schafer case, had his decision overturned by court. It included him spending a whole day in court giving evidence at one point. And he welcomed that judgment. He said, well, this is a constitutional democracy, and in a constitutional democracy, the Constitution is supreme, and my acts as President Mandela are subject to review. And that is exactly what has happened in this case. President Zuma's decision to appoint Advocate Simelane has been reviewed by the courts, and it's been found wanting constitutionally.
You seem to suggest that perhaps there's likelihood that there may be tensions then arising out of this judgment between the judiciary and the executive. Am I correct in reading it that way?
Well, I think it's no secret that in the last few months there's been a growing degree of tension between the executive and the judiciary. I think it's common knowledge, and only, I think 10 days ago, there was an announcement by Cabinet that the performance of the Constitutional Court would be reviewed by the executive, and you'll recall that caused considerable and understandable consternation in some quarters. The idea that the executive can review as if it was some part of the executive, some national department, the performance of the Constitutional Court is clearly wrong in principle. Although my own response to that was to say, fine, bring it on. I think the Constitutional Court has nothing to fear. Its performance has been laudable over a long period of time. And let's have a national conversation about the Constitution, because that's clearly needed. We need this document to have deep roots. It may not be a perfect document, but it enjoyed legitimacy in the 90s, and it needs to have deeper roots if it's to sustain itself. My concern is the Simelane judgment could be the straw that breaks the camel's back in terms of the government and the ANC, or parts of the ANC's response to the courts. There have been worrying statements in recent weeks and months by some members of the government, essentially from the right wing of the ANC, saying that the court and the Constitution is anti-transformation. Now, there's little evidence of that, if any. In fact, the court has been, I would argue in its judgments, a protector of the most vulnerable in many ways.
Let's talk a little bit about that, and I'm going to bring my other guest then, Professor Calland, but still with you. Let's talk about what the ANC and others, you say, on the right of the ANC have been saying here, because they've been saying the courts in this country seem to be encroaching on the work of the executive. Is that unfounded completely in your view?
That's the complaint, but I think one has to recognize that is inevitable in a constitutional democracy. In 1994, the decision of the elected members of Parliament then in the Constitutional Assembly, in consultation with the people of this country, decided that the Constitution should be the founding document, and that all public power and private power, for that matter, would have to operate within and under the framework of that Constitution. It is the supreme document. It is not, therefore, an elective democracy or a parliamentary democracy. It is a constitutional democracy, and that means that document is supreme. Now, if there are concerns that it is anti-transformation, fine, let's have that debate. It's important to have that debate. It is entirely appropriate that can happen. The Constitution could be amended. But the principle that executive power should not be untrammeled, that it should not be able to do what it likes, as it did under apartheid, is a founding principle of the new South Africa.
Debbie Schafer, let me bring you in, because the argument, as it relates to the Democratic Alliance in particular, is that those who are failing to win the popular vote are co-governing using the courts in this country. Is that what you sought to do when you took these matters to court, Debbie?
Certainly not. Quite the contrary, in fact. We are seeking to enforce what the majority of the population in 1994, in fact, voted for. And it is interesting to note in this particular judgment on Mr. Simelane, the FCA dealt with exactly this issue towards the very end of the judgment, where they quoted former Chief Justice Mohammed, saying exactly that. If it does not make laws which transgress its constitutional mandate, or if it refuses to defer to the judgment of the court on any challenge to such laws, it is in breach of its own mandate. So the court, I suspect, in relation to the kinds of criticism that have been leveled against the judiciary lately dealt very clearly, in fact, with this particular issue.
But
and denied that, and
sure.
that isn't what we wanted to do at all. We wanted to enforce the Constitution. We want to ensure that decisions that are made by the President and the Executive, and in fact even the Legislature, if necessary, are in line with the Constitution.
Again, then the issue of the separation of powers, Debbie, that the executive has got to govern, that the executive has got to make policies and so on, unencroached by the courts of this country. Do you accept that?
No, not at all. The executive has to make policy, but the policy has to be subject to the Constitution and the law, as every one of us, actions of every single South African have to be. So, yes, they must make policy, absolutely. The court must not make policy, and the court hasn't made policy. As far as I can see, I haven't seen one instance where the court has, in fact, made policy, but they have struck down policy as not being in line with the Constitution.
Dr. Friedman, how do you see this one unraveling, if you will, as we go forward?
Well, Kolani, the big problem is that this might not unravel. Our constitutional system might unravel if we continue on this path. Look, let me say I have mixed feelings about the judgment. I think that there is a problem in a constitutional democracy that a government can place. There are certain posts in a constitutional democracy which are there to protect us, the citizens, from government power, and there's always the danger that the government can place in those positions people who are loyal servants of the government rather than loyal servants of the people. And therefore, I wouldn't want to argue that appointments are none of a court's business in any circumstance. But I think that if courts are going to intervene in deciding who should hold public office or not, they need to be very careful about the way in which they do it. There needs to be very strict standards, and it needs to be done in very extreme circumstances. And quite frankly, there are aspects of this judgment which are very worrying. The aspect I find most worrying of all is that Judge Navsa says, speaking on behalf of his colleagues, that there is an objective standard to determine whether a person has integrity or not. Now, human beings have been arguing for centuries about who has integrity and who doesn't have integrity. The law on which the DA relied to bring this case, incidentally, this case is not fundamentally about the Constitution so much as it is about a particular law, the law setting up the National Director of Public Prosecutions, because it's that law which says that the person must be a fit and proper person. And Judge Navsa and his colleagues also seem to be of the view that there is an objective standard for what is a fit and proper person. Now, there is no objective standard, and quite frankly, at the risk of offending the judiciary, it is arrogant to say that there is an objective standard, because if you say there's an objective standard, you're saying that your view of who is fit and proper should be everybody's view, and that is not a very democratic attitude.
Well, but let's talk about what the Constitution and the Act itself considers a fit and proper person. Does it not outline the person?
No, it doesn't, Kolani, and that's the problem. Look, I'm writing something about this week. I mean, if you want to know the punchline, I think that if we are going to go on this route and we want to protect constitutional democracy in this country, what we need from the Constitutional Court on this issue, regardless of which way they're found, is that we need a very clear set of rules. The Constitutional Court needs to tell us absolutely exactly under what circumstances a person can be removed and on which they can't. If the Constitutional Court cannot come up with a clear set of standard which is acceptable to the public about how this is going to work, then it's got to declare that act unconstitutional. Because it's got to say you can't have an act which says somebody ought to be a fit and proper person if there's no clear public test of what a fit and proper person is. But let's test that. So I think it's very important that the Constitutional Court react to this as a very important issue of principle.
But let's pick up on some of the things you're saying. Objective assessment of integrity for a person who has been found by a commission no less than than the Ginwala inquiry to have delivered or given misleading and untruthful evidence, clearly people will say, well, that's obviously not integrity.
No, it's not obvious, Kolani. I happen to think, incidentally, that the Ginwala Commission is absolutely correct. I agree with the Ginwala Commission's finding on Advocate Simelane, but I'm not the people of South Africa. There are a whole lot of people out there who would say, are we now setting, it's a very good example of what I'm talking about, are we setting a standard that says anybody who's found to be untrustworthy by a commission of inquiry can't hold public office? Advocate Simelane, I don't think Advocate Simelane, incidentally, is the right person in the job, but that doesn't mean that I think judges ought to remove him. He hasn't actually been convicted of any misconduct. He's been accused of misconduct. He's never been convicted. And I think many people would also ask, well, are we setting a standard where anybody who's accused of misconduct rather than convicted should be removed? Because if we are, there are not going to be all that many people in public office in South Africa.